All right, welcome to our second session of our NWTRCC conference in November 2021. We are very pleased to have speaking with us this afternoon, attorney Peter Goldberger. Peter Goldberger is an attorney in Ardmore, Pennsylvania, and a longtime legal consultant to NWTRCC, going back to right around the founding of NWTRCC in 1982. In order to support himself in private practice, Peter Goldberger is a criminal appeals lawyer, and he's also currently serving as the president of the board of directors for the ACLU of Pennsylvania. Though, to be clear, in his discussion today, he is not speaking on behalf of the ACLU or promoting, nothing should be seen as promoting the views of the ACLU. It's just his own views as an attorney. And so I will leave it right there and hand it. Oh, so Peter will be speaking, and afterwards, again, we'll turn it over to questions, and I'm sure we'll have a lively discussion. But at this point, I will hand it over to Peter.
Thanks, Lincoln. Some of you were at the NWTRCC meeting 7 years ago this week in Earlham, Indiana, where I gave a somewhat similar talk, which was an overview of the legal principles that underlie the way the authorities of various kinds respond to war tax resistance. And I am very well aware, as I said then, and remain very well aware, that the legalisms and the legal framework of war tax resistance is not the principal concern of most war tax resistors. And I do not encourage war tax resistors to be overly focused on the legal aspects. I'm hearing somebody's voice.
Sorry, if you are not
That's
Peter Goldberger, please mute yourself.
Thanks. Yeah, so I am very aware that war tax resistance comes from a place of conscience, and that most war tax resistors would not change what they are doing if they knew more about the legalities of it, or illegalities of what they were doing. But it has been a principle of NWTRCC for a very long time, and the aspect that I've been involved in, that it benefits resistors when they are fully, accurately informed of the consequences of, or potential consequences of, their actions, risks, consequences, and benefits, for that matter. You need to know consequences to balance, if there is balancing to be done. People who do only what they are compelled to do by conscience without regard to consequences are absolutely, in the mainstream of this tradition. You might call that sort of the Catholic worker angle or approach. But there are others who view it quite differently. So when I spoke at Earlham, I took a leisurely, roundabout approach to getting to talking about a then quite recent Supreme Court decision called the Hobby Lobby decision, which interpreted the Religious Freedom Restoration Act in a way that supported religious objections to the Affordable Care Act, so-called Obamacare, and did so on principles that I thought were extremely interesting and potentially helpful to war tax resistors. Religious Freedom Restoration Act being a federal statute that requires a kind of conscientious objector recognition by all federal agencies to any and all federal programs, not excluding the IRS. But that roundabout leisurely walk that we took together, if you were with me in Earlham, to get there was through a discussion of what is civil disobedience, what is conscientious objection, and what is the constitutional protection for the free exercise of religion, and what do these three legal categories have to do with each other? How do they inform each other, and how are they different from each other? What got us interested, Lincoln and I, in doing this again now 7 years later, was that there has been quite an upsurge in the last half dozen years at the Supreme Court of discussion of freedom of religion. Not so much the statutory protection in RFRA, the Religious Freedom Restoration Act, but under the First Amendment. And there's discussion of whether the Supreme Court has taken the correct approach and is currently taking the correct approach to the First Amendment free exercise clause. So what I'd like to do for the first few minutes here is summarizing the path that we took in the discussion 7 years ago, and then get to what appears to be happening today that's new and different. Because what's new and different is not about RFRA, which is where the path ended and landed 7 years ago in Earlham, but is about the Constitution. And I know people are interested in what that means and what that protection is, and how whether it might or might not apply to you, and even if it doesn't, makes you a better American to understand what the Constitution protects and doesn't protect. So let's start with the idea of civil disobedience. Civil disobedience has quite a powerful history in the United States, and political philosophers have written about it and tried to come up with a definition of what really constitutes, what distinguishes one civil disobedience from another form of lawbreaking. And I suggested that, to my mind, there are at least two kind of categories of civil disobedience. There are those who are compelled by conscience to violate the law and expect to use this lawbreaking as a form of political change making, to see, to pique the conscience of a large number of people, or at least a large enough minority to push lawmakers to change the law that they find repugnant. So there certainly were significant elements of that in the civil rights movement, right? If you fill the jails and fill the streets with people protesting segregation, you might cause the segregation statutes to fall because the conscience of the nation would be touched, and that did to a large extent happen. And that depends on the civil disobedience being public. Some people would say, Gandhi did say, that it also depended on welcoming and embracing of punishment, because part of what moves people to change their minds about something is seeing how serious the objectors are and why, and their embracing of punishment and suffering is part of what makes it work to change. And that was Gandhi's theory, and arguably he succeeded in making a revolution in India based on that. But there are also, my way of seeing it, kinds of lawbreaking which ought to be considered to be conscientious civil disobedience and entitled to the respect and honor that civil disobedience gets in America, that is not public and is indifferent to changing the law, of which the prime example that I hold up and held up at Earlham was the Underground Railroad, a very powerful movement of civil disobedience, of law-breaking as a matter of conscience, that was absolutely not public, not designed to be public, not seeking out and embracing punishment, just doing the right thing in the face of evil, doing the illegal thing. in the face of an evil legal system. The more traditional form of civil disobedience, though, that political philosophers talk about, of doing it publicly, embracing punishment, et cetera, is probably, in addition to the civil rights movement, the suffrage movement is also a prime example of a powerful civil disobedience campaign that won legal change through relentless public protest and suffering, with a small amount of lawbreaking involved, which is the leaders would occasionally just go and cast a ballot with intending the ballot to be seized and rejected, because that was part of the publicity campaign. And I also mentioned there's also mass campaigns of lawbreaking, which are not conscientious at all, and might be or might not be considered civil disobedience, such as the massive disobedience of prohibition, which caused prohibition to fail through people just refusing to go along with it. None of those are about First Amendment freedoms or conscientious objection. Conscientious objection is quite different from civil disobedience. Conscientious objection, the way we talk about it is, and use that expression, is seeking out, demanding, or embracing and using, depending on the law you're talking about, an exemption that the law provides or ought to provide, and which you're trying to get it to provide, for people who cannot comply with the law. Either they cannot do the thing that the law demands them to do, or cannot refrain from doing the thing that the law commands them not to do. And laws can be written so that there is a category of people who are exempted when they need to be exempted for a conscientious reason. That we're familiar with conscientious objection under the draft, right? So for the first 150 years of American history, there were very little and inadequate conscientious objector exemptions, and a broader one written in 1940 to describe conscientious objectors to the draft in a way which almost precisely described Mennonite and Quaker and conscientious objectors, was lobbied for by their lawyers and religious leaders in 1940, and they got the exemptions they wanted, but they were not thinking about, may not have cared about, but they certainly were not even thinking about Catholic conscientious objectors who embraced a just war theory as a matter of religion and might be able to submit to the draft under some circumstances, but not others, depending on the nature of the war. And so, that provision had a certain definitional structure and embraced some people and not others. And I see somebody on the group labeled Daniel, and is that Dan Seeger? Is that who's there? If it isn't, I'm just going to mention that Dan Seeger and others, challenged the narrow interpretation of the conscientious objector provision under the draft law in around 1970, and the Supreme Court, in those cases, much to people's surprise, didn't reject the challenges and didn't hold the narrow definition of conscientious objector that covered Quakers but not Catholics to be unconstitutional, which in my opinion it was for that reason, but instead interpreted the statutory exemption more broadly to encompass a much larger group of people, not traditional Catholics who still lost, but people who were agnostic, people who had deeply held moral views that they didn't describe as religious and that would not, before the 1960s, have been described as religious, but were fully equivalent and parallel in their lives to the beliefs that anyone would recognize as religious in a traditionally religious person. And those people were recognized as coming within a statutory conscientious objector provision that referred to people who were opposed to war in any form by reason of religious training and belief, except it wound up covering people who weren't religious and didn't come to their beliefs by training and belief, by training. So it was, they just interpreted the statute to cover something that the statute didn't say it covered. But, you know, a few years later, as I said, the Catholic just war conscientious objector goes to the Supreme Court, and the Supreme Court said, no, the statute doesn't cover you. You're not opposed to war in any form. They lost their case. Interestingly, the traditional Muslim objectors who said we would fight in a war of good against evil commanded by God, but not a war of nation against nation, were held that they did object to war in any form as that expression was used in the statute. So you never know what a court is going to do interpreting statutory language necessarily. That's what lawyers are for, is thinking of arguments to make for their clients, and sometimes they prevail and sometimes they don't. So what I talked about extensively in Earlham 7 years ago was how, after the Supreme Court had issued a very restrictive opinion on the scope of who was protected from complying with the law under the First Amendment Free Exercise Clause, Congress came back and passed the statute, the Religious Freedom Restoration Act, that effectively created a conscientious objector provision to any and all, on the face of it, to any and all federal programs. It's been unevenly enforced, obviously, but the traditional view, before coming back to that, let me say that this traditional view of free exercise, the narrow scope of the Free Exercise Clause, honestly, the narrowest view of free exercise is the traditional view. The so-called Religious Freedom Restoration Act does not restore a traditional view of the First Amendment that had only been bizarrely rejected by the Supreme Court in the year 2000. What it restored was an extraordinarily sympathetic view of free exercise of religion that existed only from the mid-1960s to the early 1980s, effectively a kind of a Warren Court view of free exercise. But the traditional view goes back to how the Supreme Court responded in the 19th century to the Mormons. The first real free exercise cases that went to the Supreme Court were Mormon polygamy cases. And the Supreme Court said that, interpreted the Free Exercise Clause as meaning that there is, of course, complete freedom of belief, but necessarily there cannot be freedom of action based on religion if you're going to have a civilized society in which people have to obey the law. If people don't have to obey the law because it violates their religion, you have anarchy, not law. That was the philosophy of the Supreme Court in the 1870s, and it remained so until the mid-1960s. I'm leaving out the parts of those decisions where they say, and besides which it's obvious that Mormons are wrong, and that's just not really Christianity, because that's like so far from what any judge would be allowed to say, whatever he or she was thinking today. But in the year 2000, in a case called Smith versus Unemployment Division, The Supreme Court returned to that super narrow view of free exercise of religion in a case of a Native American drug counselor who himself used peyote in religious ceremonies in his tribal religion, and was fired from his job as a drug and alcohol counselor because he was a drug user by the state of Washington, and said, I'm not a drug user, I'm a religiously observant member of the Native American church, and we use peyote under controlled circumstances in our religious ceremonies, and you can't fire me under the First Amendment. And as it had been interpreted in recent years. And the Supreme Court basically went back to the narrowest definition, back to the Mormon cases, and said no, and that he lost his case. And that was so kind of shocking to the fact, because it's such a good test case, and it was so shocking to people who had gotten used to the Warren Court interlude, where Jehovah's Witnesses couldn't be fired from a job because they refused to accept a transfer to the part of the company that made weapons, and the Amish were told that they were exempt from compulsory schooling after 8th grade based on their religious beliefs. Those are the kinds of cases that were decided during that that window of generous interpretation. Well, the Supreme Court had adopted this, gone back to this very narrow view in the case of the Native American drug counselor Smith case, that Congress responded with the Religious Freedom Restoration Act in 1993. And that statute articulated the rule that had been applied in the Amish case and the Jehovah's Witness case in the 60s through the 80s, that said that a government agency had to accommodate a religious objection to complying with a legal obligation, unless had always had to protect the religious objection, unless unless the government could bear a burden in court of proving two things. One, that they had a compelling need to structure the program without exceptions, not just a valid need, but a compelling need, and that whatever accommodation they were willing to offer, or no accommodation, was the most accommodation that they could possibly offer and still have the government program run the way it was supposed to run. So compelling interest and least restrictive means are the two elements of the test that the Supreme Court had applied, as I said, in the Amish education case, and then was enacted by Congress into the Religious Freedom Restoration Act. On the face of that, that's what the statute says, and that's what it has said since the early 90s. And we started, a couple of colleagues and I, we started bringing challenges to tax penalties and requirements for tax resisters, invoking the Religious Freedom Restoration Act, starting in the early 90s, as soon as it was enacted. And we were told, oh, no, it doesn't apply for one silly reason or another that didn't really comport with the way the statute was written. But when the two test cases got to the Supreme Court, first a lesser known drug case that involved a small religious group in New Mexico that wanted to use a vegetable substance in their religious ceremonies that from South America that had hallucinogenic effects, and the Supreme Court applied the Religious Freedom Restoration Act to say that they had to be allowed to import enough of this leaf to conduct their religious ceremonies. And then that, again, most boldly in the Hobby Lobby case in 2014, the Supreme Court said that employers whose religion forbade them to provide birth control coverage to their employees because, as a matter of religious principle, they believed that it made them complicit in some sort of infanticide, had to be given an exemption from that aspect of the Affordable Care Act. And the interpretation of RFRA, the Religious Freedom Restoration Act, that the Supreme Court articulated, that Justice Alito articulated for the majority in the Supreme Court in the Hobby Lobby case, was very much the interpretation that I and a few others had been advocating for war tax resistors, that just to apply the statute as it's written would require the government to prove that they could not, for example, sequester the money of someone who's willing to pay their full taxes, as long as it wasn't, as long as on an accounting basis, it could be assigned to a non-military purpose for spending, basically the equivalent of the peace tax fund plan. And that if you were willing to accept the peace tax fund structure, that is, pay your taxes on a promise from the government that your money would be set as not used for military purposes, then you had to be exempt from paying taxes until and unless the government set up such a program, if they could. And if it was possible to set up such a program, and the argument, certainly our argument, is that it is possible, then they have to either do it or not make you pay. But as I discussed at some length in Earlham in 2014, there is a section of the Hobby Lobby case that says, of course, we don't mean by interpreting RFRA this way that it would accommodate war tax resistance. In fact, it was the only example that they gave that wasn't in the case before them, that they went out of their way to discuss and reject an argument that nobody had made in anticipation that someone would make this argument, and saying the same things that that other courts had said since the 1930s, when people first started making these arguments on constitutional grounds. Well, of course, the tax system couldn't run if there were individualized exemptions. That would be impossible. And they just said it. But RFRA, of course, requires the government to prove that they can't do, and give the objector a chance to make suggestions of things they might do, things that would satisfy the objector. I mean, so this, the legal term is dictum, of language in a court decision that really isn't about deciding the case in front of them. This dictum violated all the principles of good decision-making and of the language of RFRA itself, in my opinion, but it is embraced by a majority of the Supreme Court. So that's the threat that war tax resistance appears to pose in the back of their minds. It's like the paradigm example of where the slippery slope would lead to bad results. So of course, anyone who had such a case, and I have been saying this for 7 years, anyone who had such a case could make that argument. And while the dictum in Supreme Court decisions is treated as highly persuasive by judges in lower courts, it's not binding, it's not precedent, because it's not the decision in that case. It's language in the opinion in that case, but it's not the decision of that case. So it's considered to be the most influential of non-binding authority, but it's non-binding authority. And now, I had suggested back in 2014, right after Hobby Lobby came out. And obviously we've been thinking and talking about finding the right such case for some time, for all that time since then. First of all, there is a provision in the tax law that says you can't sue the IRS to prevent them from applying a tax to you, that all your arguments against, whatever arguments you have against the IRS in a tax situation, and I'm talking here normally about, about all the normal arguments of just saying, you miscalculated my tax, or I'm not subject to that tax, or what do you mean I didn't pay that tax? I did pay, or whatever people might be arguing, is always presented in a defensive posture. That is, the IRS comes after the person and they raise these arguments in defense. And that's equally true of any, theoretically, of any war tax argument. And in fact, we know that very dramatically from the only war tax resistance case that was decided in the Supreme Court, which was the American Friends Service Committee case in 1973, where honestly applying one of these free exercise precedents, the ones I talked about in the high watermark of the free exercise world, when the courts were claimed to be applying the test, which is now written in the Religious Freedom Restoration Act. A judge in Philadelphia ruled that the American Friends Service Committee did not have to withhold income tax from the paychecks of its employees who were Quaker war tax resistors. And the government appealed that case to the Supreme Court, and the Supreme Court overturned the decision on the grounds that they had brought that case as plaintiffs. AFSC had brought the case as plaintiffs to restrain, to get a ruling that the IRS should not be able to compel tax withholding from them, and that they were not allowed to be in that posture, that the IRS had not come after them for refusing to withhold, and therefore the case had come up in a defective procedural posture, and it was overturned on that basis. But that procedural rule stands. So a test case challenging the dictum in Hobby Lobby would have to come up in defense. Now, what would, in defense of what? Perhaps, and this is the challenge that I have always thought was most powerful, would be in defense, I would say, of the imposition of a penalty on someone who the IRS had gone after and eventually collected from. Someone refused to pay tax. The tax was then collected, and it was collected with penalties for failure to pay on time. And the reason for failing to pay on time was my religion forbade me to pay on time. So you can see how the validity of that challenge to the penalty would be protected by RFRA. And honestly, it would be better to set a precedent about a penalty than to go after the whole enchilada of saying, until you enact the peace tax fund, I don't have to pay taxes at all. But as I said before, I think that's a valid argument. I just think it's not the first precedent that would be prudent to try to set. Well, that example brings me round to the idea that we had for why 2021 was the time to have another talk and Q&A on this subject at a NWTRC conference, because sort of in the year 2000, I will just give an example. I brought a case challenging penalties of the kind that I just described to the Supreme Court on behalf of Rosa Packard. Many of you may remember Rosa. She was a Quaker war tax resistor in Connecticut, a stalwart, solid, sensible, straight ahead person. And her practice, the practice to which her conscience led her, was to place the full amount of her tax in an alternative fund kind of in escrow, and from which it could be readily collected if and when the IRS got around to it, but she hadn't paid the tax, which satisfied her conscience. And it was collected with penalties. And we then brought an action of a kind that is allowed by the Internal Revenue Code, which paid the penalties and asked for a refund of the penalties, sued for a refund of the penalties, and claimed that we were entitled to a refund for two reasons. One, RFRA, the argument that I just articulated, which was then new and before Hobby Lobby. And second, that there were exemptions, that the IRS had discretion to waive penalties for on reasonable grounds for exceptional circumstances, sort of vague standards, which I brought a copy of my Supreme Court petition for Rosa here, and I could look up the words, the exact words, but they're like that. The IRS can waive this penalty or that penalty for circumstances beyond the individual's control, or my favorite, the failure to make estimated penalties. The penalty should not be estimated payments for people that are self-employed and don't have withholding, and then don't make them for reasons of, for whatever reason. There's a penalty for not making the estimated payments, which can be waived according to the regulation if imposing the penalty would be, quote, against equity and good conscience. That's the legal standard for waiving the penalty. So we argued that the refusal of the IRS to apply these general vague standards for waiving penalties to religious reasons was discriminated against religion in favor of non-religious reasons, and that was a violation of the First Amendment Free Exercise Clause. And that is a little corner of First Amendment protection that survived the 2000 Smith case. That it is still, and has always been, and even under that law was, part of the free exercise doctrine that not only do all religions have to be treated equally, which you might view as kind of an Establishment Clause principle, but that religions have to be treated at least as well as equivalent non-religious thought systems and beliefs. And that was the second argument that we made for Rosa, and we lost that case, and it was refused at the Supreme Court. When I say refused at the Supreme Court, maybe I should stop for a second and point out that in this very large country in which there are hundreds of thousands of legal cases of various kinds every year, there is only one Supreme Court, and they only take less than 100 cases a year. In fact, in recent years, they have taken fewer than 70 cases a year from the whole country, and they get to handpick whichever cases they want to hear. They're supposed to pick them according to their own internal guidelines, suggest that they should pick them when it's necessary to resolve a dispute between lower courts about how to resolve a certain kind of recurrent legal issue that's being decided one way in this part of the country and that way in another part of the country, or is of exceptional importance that requires the attention of the highest court. So I can't say it was a surprise that Rosa's case was not taken, but it was a good case, and it made both the RFRA argument and the First Amendment argument. Well, what got Lincoln and me talking about doing this again now is the Supreme Court in the last couple of years has been very actively reviving its application of this equal treatment, or at least equal to secular reasons doctrine under the Free Exercise Clause. And this is another argument along with RFRA that I think, if even-handedly applied, would be of value to war tax resisters. And the way this has been coming up has been most recently in the COVID restriction cases. So for last year, starting almost exactly a year ago, and for several months, the Supreme Court was taking emergency cases from various parts of the country where churches and religious people were arguing that they were being restricted in their religious exercise by the application of COVID rules, public health rules that were being applied to them more strictly than the most generous rule that was being applied to some roughly equivalent secular activity. So the rule that not more than 25 people could gather in one place that New York had was challenged by an Orthodox Jewish congregation and by a Catholic congregation that met at St. Patrick's Cathedral, where you could have 10 times 25 people and they'd still be 3 times 6 feet apart, filling in, inside the cathedral. And the Supreme Court enjoined the application of those rules to religious bodies on the argument that they were either irrational as applied, like the 25 people in St. Patrick's Cathedral, or were not being even-handedly applied to equivalent circumstances that were not religious. And the most remarkable of and they were doing it in a way that was just amazingly favorable to the religious claims. That, for example, there was a case out of California where churches were subject to the same rules as concert halls and other, places where a large number of people would sit in chairs or on, benches that were quite close to one another in an enclosed space. And the Supreme Court said that was invalid because it was similar enough to what was allowed in a large retail store. They compared the church to a Costco or a Walmart. And I thought, honestly, I thought that the Congress, that the California-led agency had made a perfectly reasonable categorization of churches being like concert halls, not being like big box retail establishments, but that's not what the Supreme Court thought. So their equivalency rule for equal treatment, or at least, treatment at least as favorable, was really bending over backwards to protect the religious claimant. And that reminded me of the argument I had made 20 years ago for Rosa in that Supreme Court petition about waiving penalties for reasonable cause and circumstances outside a person's control that were applied to almost any sort of circumstance, but not a religious objection or religious inability, in this case, not objection, but a religious inability to follow the rules. With apologies to those of you whose vortex resistance is absolutely not religious, no matter how broadly you define religion, the only promising developments that I'm aware of, in the last 20 years are all in the religion sphere. But for those whose objections are religious, there are promising doors open for the right case that comes up in the right posture to make a try and not to give up, even though we have lost case after case, including the ones in which we were clearly right, as well as the ones in which we were clearly wrong. And I guess that's sort of now where I would leave it, except to say that there is disagreement among the conservatives on the Supreme Court about whether, all of whom want to be more protective of religious freedom than they see the law as being in general in America. But there's a disagreement among them, perhaps two factions, you might say, about those who want to think the right thing to do is to go back to the more generous test, the one under which the Amish were able to win in the 80s against compulsory education, and those who think that that's a slippery slope and that they shouldn't go there, and that they can be as protective as they need to be with a more generous than ever before reading of the equal treatment principle. That they can always find some secular, probably always find some secular activity that's being treated better than the religious objection, and protect the religious rights that they want to on those grounds. And the slippery slope, now I'm psychologizing. I'm not quoting anything that any of them ever said. I'm reading between the lines of the decisions that they make. And I think that the fear of the slippery slope is a fear when they are suddenly reminded that not everyone who is religious agrees with them politically. That they think that when they think of religious people, they think of people who are adamantly anti-abortion, adamantly anti-gay, like the baker, the cake shop case out of Denver. We could talk about that if you want to. I think that's a different angle on freedom of religion than the one we're talking about. But and then they suddenly remember war tax resistance and maybe abolitionism and the right, the civil rights movement and other religiously motivated progressive resistance, religiously motivated resistance campaigns, and they think, oh, this principle, whatever principle we embrace, has to be even-handedly applicable to all religions and all religious views. I mean, it's not. So their sympathy for religion is strong, I will say, and they will go there when they feel, that they should. So just to give a couple of examples, and then I think we'll be done and open up to questions, which is, so for example, there's a solid majority that is not against the death penalty on the Supreme Court. But the death penalty case that they have taken for decision this year, and which will be decided soon, is whether a prisoner on death row facing execution can be denied the right to have his pastor enter the death chamber, hold his hand, and say a prayer before the execution is carried out, which is forbidden in, I forget if it's Oklahoma or Texas, but it's one of the two. And that law is being challenged at the Supreme Court, and they took that case. And I think that the prisoners are going to win, much as they hate murderers and hate and are okay with the death penalty. And perhaps similarly, speaking of Justice Alito, perhaps the most rigidly conservative in every way, both religiously and politically, on the Supreme Court, a couple of years ago, struck down a prison regulation that forbade prisoners to have a beard that was more than a half-inch long, in favor of a prisoner who had a sincere Muslim religious requirement to grow his beard longer than that, and allowed the prisoner's lawyers to prove in court that you couldn't hide a weapon in this guy's beard, which is what the warden was saying. And once they failed to prove that he could hide a weapon in his beard, he won. And they're no fans of prisoners or of Muslims, but it was a religious freedom principle that they recognized. So I will give credit to them for integrity every once in a while, and that gives me hope that some of the claims that I've been trying to bring for many decades and are at least willing to continue trying for whatever small number of years before I give it up and retire, you know, maybe there is a chance. So let me stop there and see what kind of questions have accumulated. I'll let you manage this, Lincoln.
Thank you, Peter, for your very in-depth analysis and historical overview of this issue. I know early on there was a basic question in the chat about if you recalled the name of that early 70s case that allowed support for non-religious COs.
Oh, Welsh and Seeger. Yeah, Welsh was one case and Seeger was the other. Yeah, Welsh, I think, was Dan Seeger was the agnostic, and Welsh, I think, was the one who was just insisted that his views were non-religious, and the Supreme Court said, well, they hold, the way you describe your views, they hold the same central moral controlling force around your worldview that a religious perspective takes, and we're going to call that religious.
So here's, well, I can go back and forth between the chat to see. Susan, you have your hand up, so you can ask first.
Hey, Peter, thanks for your work over the years.
Hi, Susan.
Yeah, the thing that always makes me a little queasy, and more so now in the current political climate, is using precedent that might feel very good in terms of what we're doing, but that would be leveraged by forces on the right that would take it much further than we ever, you know, that there's so much momentum behind right-wing forces right now that I would be afraid that if we were successful in setting a precedent for, you know, war tax resistance, that it would then go much further towards something that I would not want to see happen. Is that a concern for you?
It's not a concern for me because I'm putting both my lawyer hat and my ACLU hat on now and saying that I believe in neutral principles. And I think that everybody's rights, well, everybody ought to have the same rights, including people I disagree with. And it's up to the courts to balance and manage them. And they haven't shown any reluctance to limit rights according to the needs of government power over the years. And I'm not too concerned about their willingness and ability to do so in the future. So that if I had a client who I had agreed to be hired by, or I had agreed to volunteer to represent pro bono, I would make the best and strongest argument for that client that I could and trust the system to place guardrails as they have for 200 and more years.
Thank you. I see there's a question in the chat regarding different methods of war tax resistance, and if you thought there is, quote unquote, an ideal method that, one that would look better, so to speak, in a case that could possibly go to the Supreme Court that might be looked upon more favorably.
Okay. So with that qualification at the end, I can answer the question. Otherwise, I would say what I always say to people, you know, as my lawyer hat is it's a sympathetic pacifist lawyer hat, but it's still a lawyer hat that I wear, you know, which is you should obey the law fully as far as you can, and then stop. And then when you can't, I'll do my best to help you. And everybody has to do what's right for them. And nobody should tailor their resistance to anything other than the demands of conscience. Giving a little pastoral advice there. That's not legal advice, but it's also legal advice, because if you tailor your conduct to anything other than the demands of conscience, then you are being somewhat less than sincere, and you do not have a chance of prevailing if you are not sincere. the only, I think Ruth can back me up on this, that the tiny handful of vortex resistors who have gotten into criminal trouble or even gone to jail in the last 30 years since, or 40 years even since NWTRC was founded, are people who have not followed NWTRC's counseling principles and have engaged in activities equivalent to tax fraud along with their tax resistance because they didn't get good advice about sincerity. So to quote one of my prophets on this subject, Bob Dylan, said in Absolutely Sweet Marie, to live outside the law, you must be honest. That's the line.
Thank
So
you.
where are you tonight, Sweet Marie? That's the question. That's the counseling question.
All right, I see Thad has his hand up.
Oh, that was this question that he just answered more. Can you guys hear me?
Yes.
Okay. Yeah, that was the question. I'm not sure you fully answered or not. Really what obviously people should follow their conscience, but if we had multiple vortex resistors who were religious and we're going to court, is there a particular method of resistance and particular method of what someone is doing with the funds that they would have paid
Sure.
that would be more amenable to winning a SCOTUS RFRA case?
Yes. Yeah. This is a person who has consistently taken the position that they would comply with the Peace Tax Fund model. That is, they would pay their taxes in full if the government would spend them for a non-military purpose, could channel the funds, which, by the way, I'm sure they could, because on the face of the 1040 form, as I have often pointed out, there is a checkbox that says, do you want $3 of your taxes to go to the presidential election campaign fund? So apparently they are telling people that that the government has the capacity to spend some, or presumably then all, of that individual person's taxes for or not for this particular purpose. Well, if they can do that, then they can do what we want. So a person who is willing to pay, perhaps who has put their money in escrow to show the good faith that they're not spending it on themselves in the meantime, or can document that they have increased their charitable contributions to spend the same amount of money for charitable purposes and then not deducted it the next year on their return as a charitable deduction. So they take absolutely not benefiting in any way from the resistance financially, or one way or another, not benefiting financially from the tax resistance, and who have been given a penalty, as I said, that is subject to a discretionary waiver by the IRS that the IRS refuses to waive in any case on the basis of religion.
Thank you
that
so
would be
much,
my
Peter.
imaginary ideal case, which is HA's case, right?
Right. Thank you so much.
There was another question in the chat, which this is dependent on how familiar you are with the inner workings of the Kings Bay Plowshares case, asking if their use of RFRA, do you think it would bear any fruit for a war tax resistance case?
So as I recall, that was, so we're talking about a very, they won, that's the one that prevailed on appeal, right? In the Court of Appeals of all the Plowshares cases. And on the basis that the judge had not applied RFRA to the mental state element of the crime, I think, if I remember this right. And it's a good example of it. It was written, as I recall, by one of the most conservative judges on the Sixth Circuit, who believed in honest, fair, down the line, apply what the statute says to everybody equally, whether I agree with them or not. And that's, yes, if I remember right, I think that's exactly what that was. And if I'm not, then the person that asked the question can ask it again in another way so I can understand it better.
No, that's not the same case. In fact, this is Robert. I'm not familiar with the case you're talking about, so I'm interested in learning more about it. No, these are the 7 Kings Bay plowshares who went
this
on.
was Rice. It was actually Sister Rice.
Megan Rice and her 2 folks at Oak Ridge.
That's the one you're talking about. The Oak Ridge case. Yeah. Okay. Yeah. So what were you asking about, Robert?
The 7 at Kings Bay Naval Base in Georgia. The local court conceded that that they did in fact meet the criteria for being the religious criteria of RFRA, but then denied their RFRA argument on the basis of the fact that basically, you know, the government has a compelling interest to have nuclear weapons. And I don't think anything has happened on the appeals level with it yet. But it's the first time where the court actually admitted that as religious, conscientious people, the actions they took were sacramental and fell under the protections of RFRA, except that they didn't meet the other criteria.
Yeah, I mean, so tying your question to the previous question, a person who claims a religious compulsion to destroy government property would not be my favorite test case.
Eleanor, you put something in the chat, but I also see you have your hand up, so we'll just let you ask it.
Okay, before I ask my question, if you could spell out the full names of the Welsh and the Seeger cases in the chat, perhaps, for us, that would be nice.
Well, they're either United States versus United States, and they're U.S. Supreme Court cases from around 1970. And actually, Google does better legal research than Westlaw these days. So I think you'll find them very quickly.
Okay, my other question was, isn't it's possible it's being possible to be sincere in one's actions and feel that the peace tax fund is an accounting trick that,
of course.
So
I think probably most war tax registrars probably do feel that. I think it's probably a minority who would be satisfied with the peace tax fund.
So you were saying that a case would be good if a person was sincere, and you were defining sincerity as they're being willing to pay their taxes to a peace tax fund.
If I did not, you either misunderstood me or I misspoke. That is absolutely not anything I would ever say or believe. If I said it, it was a mistake. People can be sincere in all kinds of beliefs. I was only saying that an example of someone who would make a palatable test case that would be most likely to win in the real world.
Okay, so a person who was not satisfied with the peace tax fund could be sincere, but they wouldn't make a good test case. That's what you were saying.
I think what I said is even less than that. I think I just said they wouldn't make my favorite best test case, but I can imagine any number of other test cases that would be interesting to consider.
Could you tell us about some of them?
Yeah, I mean, people who don't hide, whose money can be collected with ordinary collection methods without voluntarily paying it. So it's the least.
They don't give, but it's easily seized. That's what
right.
You're saying.
Right. And the refusal to pay voluntarily is a sincere religious exercise.
Thank you. I see Jack's hand is up.
Hi, Peter. I'm thinking as you talked about like Elizabeth Boardman now, who lost her case, but is it ever possible for someone like her to bring a case again because of the fact that the makeup of the court has now changed?
my recollection is that Elizabeth and her lawyer in California, right?
Yeah,
Yeah, insisted on filing a case as plaintiffs, despite my saying the AFSC case in the Supreme Court says you can't do that. And it was dismissed on the ground that I said it would be dismissed on,
right,
and not on the merits.
right.
It was not brought in the correct procedural posture, even though we know very well what the correct posture is, which is not what they did. So
Right.
it's not to be harsh about it, but
Right.
I said, don't do that. And they did it and they lost.
But then I think of other people like, say, David Bassett. I mean,
So I'm saying that has nothing to do with Elizabeth Boardman's sincerity or whether she might be a very suitable test case, just not by trying to sue the IRS when the Supreme Court says, and the Internal Revenue Code says you can't.
okay. Well, what about
So
when I think of someone like David? He's paid multiple fines over the years.
mhm.
Is there no standing for someone like that? No method?
The IRS has to be doing something now against the person, and their defense would raise the issues that I'm talking about.
Okay.
It's not about what happened to the person in the past. It's defending against a current IRS action against the person by invoking these principles.
Right. But if they
And happily, the IRS leaves most of you alone most of the time.
right,
That's not a bad thing.
right. But I know there are people who actually keep two different bank accounts so that when the IRS seizes one, they can use the other to pay their bills, so they don't end up with late
Right.
fees and stuff. And I mean, there are people like that who support the Peace Tax Fund.
Sure. Yes, so that's, an illustration of perhaps someone who the government has would have a less compelling argument.
Right. Okay.
Right. So for example, the Philadelphia Yearly Meeting of Friends, right? The largest Quaker body in the greater Philadelphia area. I've represented them a number of times. Their principle has been, although that the meeting as such is not a tax resistor, they support all Quakers who are members or employees of the meeting who are tax resistors if and when the meeting is called upon to aid the IRS against their members or employees. And so when they were setting aside withheld taxes that should have been they would withhold from people's pay who were resistors and employed by the meeting the amount of money that was due. They would calculate it correctly. They set aside the amount out of the paycheck that was due as federal taxes, but instead of sending it to the IRS, put it in a certain bank account, and they had a separate bank account for that purpose. And I was authorized by the meeting to tell the IRS agent when and if he or she came after them, which bank account it was, so that they could otherwise meet their payroll and pay their bills.
Mhm.
I'm not saying that would be consistent with everybody's principles, but it was consistent with their principles, so it was okay with me.
Thank you. There's another question in the chat about this is not exactly on our exact topic, but about Fifth Amendment rights, and do we have the right not to incriminate ourselves by telling the truth, for example, turning over our complete financial records to the IRS?
Well, obviously, war tax resistors have the same Fifth Amendment rights as anyone else because the conduct could easily be construed as criminal, not that it's ever prosecuted in the ordinary case, but because it could be prosecuted, yes, there's a Fifth Amendment right. But whether the Fifth Amendment protects against turning over records is a complicated question of Fifth Amendment doctrine, to which the answer is generally no. And I don't want to go any further than that and impose on the rest of you the whole seminar on Fifth Amendment rights. But I did win a Fifth Amendment case recently for the ACLU against someone turning over the password to his iPhone. but it was because they demanded that he tell them the password. It wasn't to turn over a paper where the password was written down, which might have been different.
Also, HA had a couple questions real early on. I think you've answered them, but I'll, if HA, if you feel different or if you wanted to rephrase one of them, feel free to ask.
I could reiterate perhaps, let's see, it was kind of the second one about estimated tax penalties. Some of us have paid those along the way. Could they be considered excess charges that the IRS makes? And if so, could those be appealed through the courts as some sort of a legal suit that
I think it would be a suit for a refund. You'd pay them and then sue and then demand a refund, and on the ground that your failure to pay on time was due to your religious inability to pay. And they would deny it because their regulation says any individual unusual circumstance other than religion can be considered, and that violates, in my opinion, obviously the equal treatment principle. And you would appeal the denial of the refund to the court. That's the posture that Rosa Packard's case went through 20 years ago.
if we try to do that, would we try and do that individually, or should we try and organize some kind of a class action activity?
Now, I'm afraid it would have to be the individual, because it's defensive. The IRS is not going after a group of people, so your response can't be as a group.
Okay.
Unfortunately, because it makes better politics to do it together, obviously, the solidarity of it.
Thank you.
You're very welcome.
I see Paula has her hand up.
Hey, Paula.
Hi, thanks, Peter, for being with us. Just to clarify again, your ideal case for Supreme Court, the penalty part of it. People who are given a penalty subject to the discretion of the IRS. Now, you said the best situation would be someone who goes ahead and pays the late fees, the penalty fees, and then wants to turn around and ask for refund. But what about for example, them seizing part of your Social Security payments?
That law is very frustrating. I don't know enough about how that works and where the chinks in the armor might be, if there are any, on that law. That's coming up a lot, and I wish I knew more about that, but I don't.
Okay, and then related to that, the passport thing, where if you've not paid more than 50,000, they don't let you get a passport. Those are penalty. I mean, those are fine. Those are not other besides financial. That's another penalty.
Yeah, I don't know if there are exemptions from that for good cause or not.
Okay.
If there are, the religion would have to be treated equally.
And then as far as the financial penalties, once again, like I do have I have quite a bit of penalties owed.
I know all about your taxes. I get a copy of every one of your IRS notices because I once represented you.
But
they send me mail about you all the time.
But what you're saying is that I can't, or people like me wouldn't be a good test case because we haven't paid those penalties. Is that what you're saying? We'd have to pay
as far as I can see. Yeah.
Okay. All right. Thank you. That's what my answer.
Yeah, and you're probably happier. Wouldn't you rather be successfully not paying from your point of view than being a martyr in court?
Yeah.
Don't get excited about a test case. It's not like your favorite thing to do.
Okay. Okay. Thank you. Thank you.
Right. You're very welcome.
Eleanor has another question.
Do you still get
No.
IRS?
I don't know why not. I once represented Eleanor also, but that was in the late 80s, right, Eleanor, that case?
I don't remember. There are moths making
Yeah.
holes in my memory of things.
and
Well-
my files, but no, I don't get any mail about you, to say,
I wanted,
except from you sometimes.
I just wanted to let you know, I filed in 2016 and 2017 when I made a smidgen of money. So I'm back in their sights again.
That must have confused them. Okay.
Do we have any other questions? Right now, I don't see anyone with their hand up, so this is your time to come forward.
So my last comment to Eleanor actually is a perfect introduction to Resistance 101, right? When I said, oh, you filed something, you filed in 2016, that must have confused them. So the basic principle that contradicts of Tax Resistance 101 is no, you're wrong. There actually is nobody at the IRS who knows you exist. It's a big computer and hardly any people.
What I meant is I'm
just joking. I'm just teasing.
They send me dunning letters.
Yeah.
And I am, I'm capable of being seized from. I had gotten past that point, and now I'm back at the point where I couldn't have a bank account. I don't know that would PayPal be safe?
Let's not do individual counseling now.
Yeah, well, those are great questions for coming up in 101 or 201, but I'll turn it over to Thad.
Sounds like a 201 to me.
Right. Hey, great plug, Lincoln, for the 201 and the 101. So, Peter, this is a question based on, I think, the first question that was asked about, say, right-wing religious things. Like, would it be, in your opinion, beneficial to, say, the rights of at least religious war tax resistors were there to be a SCOTUS RFRA precedents for, say, this is very hypothetical, but suppose that the Hyde and Helm amendments or whatever were done away with, and there were federal funding for widely for abortion. If a pro-life war tax resistor were to win a case for that, where they would pay their taxes, but it would go to something and not fund that, would such a precedent benefit religious war tax resistors?
I would think so.
You would?
I do think so. Yeah.
Okay.
Of course. Yeah. And, I'm not denigrating anybody's religious principles. I mean, even if I disagree with them, and even if I hope they don't prevail in the political forum, I still think people are entitled to believe what they believe. And I support them in acting on their beliefs, as long as they don't hurt other people.
Yeah. And is there anything, do you deal with any, I know that some states have things similar to RFRA. Are you aware of any opportunities or changes there that could be used as a precedent for federal RFRA?
I don't think the federal courts would view it that way. Okay. I have had a couple of clients who refused to pay their state income tax, or in whole or in part because of the death penalty or other reasons. And some of them actually got accommodations approved from their state, agencies from under those laws. I mean, those laws, each of those laws is somewhat different. The Pennsylvania religious freedom law, for example, is quite different from federal RFRA. And just to reiterate, the RFRA that I'm talking about applies only to federal agencies. It does not apply to state governments and state agencies like state prisons or state zoning rules or whatever. Those are completely different laws.
Thank you so much.
Mm-hmm.
Any other questions for Peter? Last chance. Peter, any closing remarks?
No, it's just, I love talking about these things and thinking about them. And I so appreciate, what you folks are doing and the witness that you're making and your willingness to hang in there over the long haul. I mean, just don't forget women's suffrage, it's a 100-year struggle. You never know what's going to prevail or when.
Right. So thank you, a huge, on behalf of everyone here, I'm sure, thank you so much, Peter, for taking this time out of your day today.
Thank you, Peter.
Oh,